Good morning, folks. It is 9 a.m. and the Colorado Oil and Gas Conservation Commission's meeting for this morning is ready to roll. We will start with roll call. Hearings Manager Larson.
Thank you, Mr. Chair. Commissioner Gibbs. Commissioner Gonzalez.
Here.
Commissioner McGowan.
Here.
Commissioner Mesner.
Here.
Commissioner Nanjapa.
Here.
Commissioner Putnam.
Here.
Commissioner Robbins.
Here.
Mr. Chair, you have 6 out of 7 commissioners present.
Excellent. Welcome, everybody. Good to see everybody's faces. This morning, we will be undertaking an executive session on 3 matters, and then we will be coming out of executive session and having deliberation. This is not a rulemaking hearing today, as we have done in the past, but instead this is a meeting for us to undertake the executive session. I would turn it over to Assistant Attorney General Davenport for any initial comments before we have a motion.
Thank you, Mr. Chair. Commissioners, I'll read my standard script and then we'll have a motion to go into executive session. Pursuant to Colorado Open Meetings Law, the Commission is entitled to enter into executive session at this meeting for the purpose of discussing pending or imminent court action and to receive legal advice pursuant to Colorado Revised Statutes, Section 24.642(3A), Roman 2. The topics of executive session were identified on the agenda for today's meeting. They are to receive legal advice and analysis on the Commission's authority to initiate litigation to enforce Order Number 1B609, the Commission's authority to issue and enforce cease and desist orders, and the Colorado Court of Appeals opinion in Wildgrass v. COGCC 19 CA 1212. I do need to make one correction to the topics on the agenda. They refer to initiating litigation in Denver District Court. That is probably not the accurate forum, so we'll be, in the minutes, deleting the words in Denver District Court from the topics for executive session. Mr. Chair, I invite you to encourage a motion to enter into executive session for the matters and purposes I just named.
So encouraged. Do we have a motion?
I motion that we move to executive session to discuss the matters that Assistant Attorney General Davenport mentioned beforehand.
Second.
We have a motion and a second. Is there further discussion? Seeing none, all those in favor signify by saying aye.
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 Any opposed? All right, seeing none, the motion to enter executive session for the aforementioned purposes has passed. Hearings Manager Larson, if you want to bring us into the appropriate executive session breakout room, please do so. And for the record, I note that Commissioner Bogue just joined us. Good morning.
Hi, guys.
All right, welcome everybody. It is 11:04 and the Commission has undertaken its executive session on the 3 topics that were agendized, and I would now turn it to AAG Davenport for next steps.
Thank you, Mr. Chair. Commissioners, we're returning from executive session. During the executive session, the Commission received legal advice on the matters identified in the agenda. Those are Commission's authority to initiate litigation to enforce Order Number 1B-609, the Commission's authority to issue and enforce cease and desist orders, and the Colorado Court of Appeals opinion in Wildgrass v. COGCC 19 CA 1212. Mr. Chair, I invite you to encourage a motion to exit executive session. I should add that the Commission did not make any decisions in executive session today and no votes were taken.
Thank you. I agree with those 2 points, and we are looking for a motion to leave executive session.
So moved.
Second.
We have a motion and a second. Do we have further questions? Or seeing none, all those in favor signify by saying aye. Aye.
Aye.
Aye.
Any opposed? Okay, AAG Davenport, I believe we were out of executive session and back in public session. Do you have next steps for us?
I do. Thank you, Mr. Chair. Commissioners, there are 2 decision points in front of you as we exit executive session. The first is whether to initiate litigation against operator Marilex Resources to enforce order number 1V609. And the second is whether to file a petition for writ of certiorari with the Colorado Supreme Court on the Court of Appeals opinion regarding standing in Wildgrass v. COGCC. I recommend that we take up the initiating litigation against Marilex issue first. And in that instance, I think staff has a few things that they'd like to say to you in that regard. After staff provides their opinion to you, you're welcome to ask questions of staff, and then initiating litigation, if you would like to do that, would require a motion and vote of a majority of the commission.
Very good. Thank you very much. Mr. Schultz, you are unmuted. Perhaps you will be the primary person from staff to tee up the first matter.
Thank you, Director Robbins. Good morning, Commissioners. My name is Scott Schultz. I'm an attorney with the Colorado Attorney General's Office representing COGCC staff. And I am requesting that the Commission, through the State Attorney General's Office, bring suit pursuant to Colorado Revised Statute 3460-109 against Marilex Resources Incorporated in the appropriate state district court due to their failure to comply with Commission Order 1V609. And with that request, COGC staff and I are happy to answer any questions that the Commission may have.
Very good. Does commissioners have any questions? Commissioner Nanjapa?
Thank you, Mr. Chair. And I'll look to AAG Davenport or AAG Schultz if this is the appropriate time to ask these questions. But my understanding is that there have been multiple attempts to work with the operator to come into compliance and multiple notices to try to achieve compliance, and that these have not been successful. Is that correct?
That's correct.
I think that's a fair characterization. And I also think that the order itself was an attempt to get Marilex into compliance as well. The original order 1V609.
Further questions from staff? Or, I'm sorry, from commissioners to staff. Commissioner McGowan.
Maybe just staff's opinion about, I feel like maybe staff feels like we've gone as far as we can with conversations and meetings, and this is kind of the next step that we need to take in order to achieve some compliance.
Yeah, I can feel that one. I mean, this is a situation that's dragged on, I mean, literally for years. We're in a position now where it's one of the more egregious violations of an enforcement order, certainly that I'm aware of. And we were allowing Marilex to try and sort this out with the BLM, given the number of federal wells that are at issue here. We recently learned that process had just completely broken down. And so, you know, that really leaves us with few options. We went the option that we have at our hands, which is to issue NOAVs, but we don't think that's going to resolve this situation. So we're kind of left with little, you know, few tools. And this is one of the tools that we rarely, if ever, use, but we think it's appropriate here. So we think the NOAVs, which we've issued, couple that with a district court action that might get us some different remedies. We think that's appropriate, and certainly this is a good situation for it.
Director, if I just may add, Commissioner McGowan, the order 1V609 is from late 2016. So again, this order provided Marilex with an opportunity to get into compliance and to show the commission that they are able to comply with the various violations that were involved in that order, and they have not.
Other questions from commissioners? Commissioner Nanjapa?
Thank you, Mr. Chair. Yeah, and I wish you could, or I was wondering if you could also comment a little bit further about how this particular effort to bring the operator into compliance has been different than other efforts with other operators where there's been an NOAV issued and corrections that have been requested, and just kind of describe how this one is a little bit more unique.
Yeah, so this one's unique. Mr. Schultz touched on this. This was an order issued in 2016. It had a pretty extensive compliance plan. We were hopeful that this would result in compliance, which is everyone's goal. It clearly hasn't. You kind of contrast that with other operators where either they have just given up and gone completely silent. They're no longer an operator, so we end up claiming their bond and putting them out of business and putting their wells on the orphan well list. You kind of compare that to this situation where we had some hope, and we also kind of considered this their last chance, and they just have failed to do it. So these wells might end up on the orphan well list. We don't really know, but we can't sit there and abide by them failing to comply with an enforcement order, which we, like I said, considered their last chance. And like I said, it's a pretty egregious violation. It's not like they've missed a well here or there. It's pretty much everything they were supposed to do over the last 2 years. So that's how I see it, as a different situation. It's not an operator that's completely, disappeared. They have wells, they're producing. It's an operator, but they've just chosen to ignore our order for years.
Thank you, Mr. Farron. Are there any additional questions? All right, seeing none, does any commissioner care to make a motion? Commissioner Nanjapa?
I think I may have seen Commissioner McGowan's hand, so I'll defer.
Oh, sorry, Commissioner McGowan.
So thank you, Mr. Chair. I'm not sure this is the correct motion for me to make, but the one that I would like to make is to give permission to staff to pursue litigation. I don't know if it needs to be more detailed than that, AGG Davenport, but that would be my preference.
Sure, I think that gets to the essential deep part of it. The only thing that I would add, Commissioner McGowan, is that this is a direction to actually my office, the Attorney General's office, and the council that represent the COGCC to initiate litigation against Marilex Resources to enforce order number 1V609.
So with that detail added and amended, that would be the motion that I'm putting on the table.
Very good. Thank you, Commissioner McGowan. Do we have a second?
Second.
Okay, we have a motion and a second. Do we have discussion? Commissioner McGowan.
Thank you, Mr. Chair. In reading the notice of violation and the fact that it's taken a very long time and staff has expressed, I think, there are multiple efforts to try to get the operator into compliance. I think this is, from what I'm understanding and gathering from feedback, it's really kind of our only option left to try to work with this operator to get into compliance and address these 75 wells. And so I would support this motion.
Commissioner Gonzalez unmuted first, so we'll let him go first, and then Messner, and then Commissioner Nanjapa.
Thank you, Mr. Chair. Yeah, I just want to say that in my understanding of this situation and what we've heard from staff and what we've learned in executive session is basically that we've exhausted all options as it comes to working with this operator, and the decision to move forward into litigation is not made lightly or frivolously, and given all the thought that's been put into it and what we've heard, I support that motion.
Commissioner Messner.
Thank you, Mr. Chair. And I would concur with my fellow commissioners on this. I do, I would like to just say that I do think that the vast majority of operators work hard to be compliant with the regulatory processes that are required by COGCC. And it's unfortunate to see the offline operator create black eyes for this compliance procedure. The compliance order was developed in cooperation with the operator. It certainly was not optional. And so I appreciate the step that we're taking here to move forward to ensure enforcement of the compliance of our regulatory processes. So I support this.
Thank you, Commissioner Messner. Commissioner Nanjapa.
Thank you, Mr. Chair. I just would agree and echo what my fellow commissioners have said, and just want to both acknowledge, similarly as what Commissioner Messner said, that we have many other operators that are working very hard to remain in compliance where they can. And while I do understand that there have been some efforts or at least attempts from Marilex to come into compliance, they have not been able to follow through. And therefore, we've exhausted our options. And as Commissioner Gonzalez said, it seems like this is our last resort, and I support this effort.
Thank you, Commissioner Nanjapa, and I too support this motion and this direction. And Director Murphy, were you waving at someone else, or were you wanting to say something? Okay.
Sorry.
Not a problem. Okay. With that, I think we've concluded discussion on the motion, and we would take a vote. I think we can just do this via oral vote. All those in favor of the motion with the direction to the Attorney General's office signify by saying aye.
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 Any opposed? Seeing none, the motion carries. Our last order of business this morning is to address the Wildgrass v. COGCC appellate case 19 CA 1212. AAG Davenport, do you want to set the script for us on this?
Happy to. Thank you, Mr. Chair. Commissioners, you have a relatively discrete decision to make here. It is whether or not to file a petition for writ of certiorari with the Colorado Supreme Court regarding the Court of Appeals decision on standing in the case that the chair just named. That would be just simply if you so choose, a motion not to file a petition for writ of certiorari, or a motion to file a petition for writ of certiorari. Either way, it would require both a motion and a vote from you, and I'm happy to provide some additional detail if you require it.
Kyle, AG Davenport, do you want to speak to the one issue that is before us, the standing issue, and just give some very brief context on that for us?
Sure, I'm happy to. Thank you, Mr. Chair. Commissioners, in this particular case, there was an argument made by the commission in briefing some time ago that the plaintiffs / appellants did not have standing in regard to what is a kind of a technical legal argument about the legally protected interest. The Court of Appeals rejected that argument by the commission and held that the the plaintiffs/appellants did have standing. The Court of Appeals actually reversed the district court. The district court agreed with the commission there. And so the question before the commission is whether or not you would like to have my office file a pleading that requests the Colorado Supreme Court review that decision by the Court of Appeals that the plaintiffs, appellants in this case, have standing.
Thank you for that. At this point, does anyone have questions for Mr. Davenport before we get into discussion amongst ourselves? Okay, I'm not seeing any questions. I'm happy to lead off on discussion. I'm not in favor of filing a writ of certiorari to the Supreme Court on the standing issue, and I'm primarily influenced by the fact that this standing issue is one that was raised in the context of our pre-181 rules. We have since preliminarily adopted new standing rules in the 500 series that does provide hearings and standing in greater capacity to individuals throughout the state of Colorado and the work that we're doing. And I believe that we should focus our efforts on those efforts as opposed to looking backward to the old standing rule. And that may have been too concise of a summary, but that's kind of my position on this. Do others have thoughts? Commissioner Messner.
I concur.
Appreciate that. Others with thoughts? Commissioner Nanjapa.
Thank you, Mr. Chair. I concur as well.
Okay, I'm seeing no further thoughts, which is fine. AAG Davenport, it appears that we do not want to seek cert here. Do we need to do anything if that is the case?
No, I don't believe so. I think if the commission was interested in filing a petition for writ certiorari, then a motion and vote would be required. In this case, my office will take this as direction from the commission not to file such a petition, and we will simply move ahead with that litigation as directed by the Court of Appeals.
And just so that everyone is aware, that direction from the Court of Appeals then is to basically take up the substance of the litigation, because this was dismissed on motions, and so it'll go back to the district court and your office will defend the commission on the substance. Is that right?
I think that's accurate. Ultimately, we will go back to the district court on the substance of the plaintiff's first claim. The plaintiffs do still have an opportunity to file their own petition for cert on the claims that the Court of Appeals upheld the district court's dismissal on. And we'll have to see if they do that. But ultimately, we'll be headed back to the district court.
Okay. Thank you for that. Are there anything else from commissioners this morning? I believe that concludes our agenda. And I believe that we will reconvene Monday, I think that might be the 26th at 9 a.m. to take up the 900 series. And do we need a motion to adjourn to that date, or are we good since we've already got that scheduled?
Mr. Chair, we're good. You did that motion to continue or to adjourn to that date when we closed the brief hearing on the 1200 series, I think. So we can just move to adjourn.
Great. Thank you everyone for your attendance. I really want to thank the enforcement staff as well as our cadre of AAGs that are helping us through these times. And with that, I would look for a motion to adjourn.
So moved.
Second.
All right, we have a motion and a second. Any further discussion? Seeing none, all those in favor signify by saying aye.
Aye.
Aye. Any opposed? Great. Looks like we're adjourned. We will see everybody Monday morning.